Tonight, a stunning blow to the case that sparked the Me Too movement. Disgraced movie mogul Harvey Weinstein had his felony sex crime convictions overturned today by New York's highest court. CBS's Rachel Duncan has been covering the story since the scandal broke in 2017, and a warning: some of the details are disturbing.
Tonight, disgraced former Hollywood producer Harvey Weinstein remains behind bars after a New York appeals court ruled he did not receive a fair trial. Weinstein's attorney, Arthur Aidala.
This was a case about perversion. Well, in that courthouse at trial, the laws were perverted because there was so much pressure, because Harvey was the face of this movement, that he had to be convicted.
The court found that in 2020, the judge, quote, erroneously admitted testimony by allowing women who were not part of the case to testify that Weinstein had assaulted them. CBS News legal analyst Ricky Kleeman.
He would get a more fair trial, according to the Court of Appeals, because these other prior bad act witnesses will be excluded.
The decision comes more than 4 years after the 72-year-old was found guilty and sentenced to 23 years in prison for sexually assaulting 2 women. Lauren Sivan, who never testified in court, says in 2007, Weinstein masturbated in front of her at a dinner party.
Do you think overturning Harvey Weinstein's conviction has an impact on whether or not people who say they've been sexually assaulted decide to speak out?
It will 100% have a chilling effect on victims coming forward. I mean, think about it. Think about how hard it is to come forward in the first place. You know, whether or not you're even believed.
The New York District Attorney plans to retry the case, but keep in mind Harvey Weinstein faces a 16-year sentence in California for sexual assault. His attorneys say they want to look at that case too. Nora.
But for now, he's in jail. Jerika Duncan, thank you.
And good afternoon. Welcome back Inside the Law. I'm your host, Philip Holloway. Today, we are going to cover 2 topics. And the first one is going to have to do with the issue of basically a fair trial. And what does that mean? Those of you who have been here before, and maybe those of you who are new, understand that what we do here is we explore the real criminal justice system. And we do that by going and taking a deeper look inside actual cases that are in the news. And there's other cases in the news other than the Harvey Weinstein case that have to do with the question of, is somebody getting a fair trial? But today, we get to talk about a different New York case, and of course, with Harvey Weinstein. Now, this is obviously a case that invokes lots of passions by people. You saw in that news clip people talking about how it's hard enough as it is to come forward if you're a victim of sexual assault, and of course that is true. And so what the Weinstein case illustrates is the sort of competing interests of what a criminal defendant gets in terms of fairness in their trial and due process. And that's weighed against other, practical considerations and social considerations. And at the end of the day, the justice system, it cannot function unless there are safeguards in place to make sure that criminal defendants get treated fairly, because you're presumed innocent. Everybody who's arrested is not guilty. Not everybody who's arrested is guilty. And a lot of people, in this country, we have executed people who were innocent. You need not look any further than the rates of exoneration throughout the nation. With the advances of things like DNA and all this, we now know that there's a considerable percentage, and that exact percentage is unknown, but there's a considerable percentage of people who are in fact innocent, who have gone to death row. They've served decades in prison. And so this is not really about Weinstein. We're going to use the Weinstein case, but this is about the bigger principle of fairness in the justice system. And while we're waiting on a few more people to get in here, I just want to take a minute to say thank you to everybody. We have now on this channel we're over 26,000 subscribers, and we are closing in on 30,000, hopefully sooner rather than later. But I just want to say thanks to everybody who has subscribed, and do me a favor, ask your friends and relatives and anybody you know who might have an intellectual curiosity about anything like this, and just ask them to check out the channel and to please subscribe. All right, before we get any further into it, without further ado, who else is better to talk with us about fairness in the justice system other than our friend Rachel Kaufman? Rachel, welcome back. How are you today?
Hi, Phil. Happy to be here.
Oh, listen, this is look, these are always fun, and you know, Rachel brings a certain perspective to this that I find to be very, very useful. Rachel has a lot of experience. She deals a lot with Fulton County, which we've talked about, and there's nobody better to talk about the need for fairness in the justice system than somebody who's a regular in the courts of Fulton County. So anyway, Rachel, do you remember taking evidence in law school?
I do.
Now, those of you who are attorneys, or maybe some of you who are in law school watching this live, or perhaps in the future who might watch it or are in law school, you know, evidence is one of those courses that either you love it or you hate it. I happen to really like it. I had a really cool professor that showed us movies like My Cousin Vinny, which, by the way, is obviously a work of fiction, but there's a lot of things about My Cousin Vinny that illustrate how the rules of evidence work in real life. So my professor made it very easy. But Rachel, when you took evidence in law school, what did you think of it?
I also had a really positive experience in evidence, because I guess when you go to law school, you know you're going to take things like contracts and civil procedure, and that's kind of boring. But like evidence basically is like the playbook, like what it basically governs fairness in a trial, or it attempts to. And so the rules of evidence kind of guide how a trial goes, what evidence a jury hears, and what's relevant and what's not relevant.
Well, speaking of relevant evidence, let me see that, you know, the rules. We could talk all day about the rules of evidence, and we still would not be able to cover it all. There's just so much there. But one of the rules that came into play in the Weinstein case, and with apologies, I'm going to cover up both of our faces just a minute. This is a Federal Rule of Evidence 404B. All right. Now, what this rule says, evidence of a crime, wrong, or other act is not admissible to prove a person's character in order to show that on a particular occasion, the person acted in accordance with the character. Permitted uses, it says, notice in a criminal case. This evidence may be admissible for some other purpose, such as proving motive, opportunity, intent, preparation, plan, knowledge, identity, absence of mistake, or lack of accident. All right. So what this is about is we call it prior bad acts. Okay. This is, you know, you want to judge somebody when they're on trial based on the facts and the evidence against them on this case. It's not fair to just bring in every bad thing or every crime that somebody might have committed in the past to show that they're a bad person, or they have a history of getting arrested and so on and so forth. We want them to be tried on the facts of this case and only this case. And if a conviction cannot be obtained otherwise, then so be it. It's a not guilty. You can't just bring in everybody's past that and everything that they may have done wrong in the past and use that to slime them so the jury will hate them. And so what the rule says is that generally you can't do that, but sometimes it does come in. And the way that I like to explain it is if the prior bad act or prior crime, it doesn't even have to be charged. If it's a prior crime that is so similar in nature that it tends to show the criminal signature, so to speak, of the accused, then it can be admitted, and judges have some discretion. However, that's not the end of the story, because the evidentiary analysis requires something else. And so this is Rule 403. It says, although relevant, evidence may be excluded if its probative value is substantially outweighed by the danger of unfair prejudice. So let's talk about probative value first. That means if something is probative, it means it tends to prove something. It's probative of the issue at hand. But if its probative value is substantially outweighed by the danger of unfair prejudice, then it can be excluded. So even if it might otherwise be admissible under Rule 404, if it is so overly prejudicial that it causes an unfair trial, then it should be kept out. Rachel, that's my analysis of it, and I want to know if you agree with it.
So from a more opinionated perspective, as I see it, as 404B, which is similar transaction rules they say that evidence shouldn't be brought in to prove that this person acted this way now. And then they've got a list of exceptions. The exceptions swallow the rule. The general way in practice that it works is that everything comes in. Usually it comes in because the trial court defers to the state, the prosecutors, and the prosecutors say it's similar enough based on a proffer of the facts, and the judge.
Tell us what a proffer is.
So basically, the prosecutor doesn't even have to bring in the witness. They just tell the judge what their witness is going to say, what this similar transaction witness is going to say, and how that's similar to what they're being accused of. It always comes in, and it's interesting because on appeal, I believe the standard in most places is it has to be an abuse of discretion to have allowed it in.
That's right.
And so you can just imagine the unlikelihood of having a case overturned based on similar transactions. So, in the appellate world, it's rare. However, what I've noticed lately is that individuals like Harvey Weinstein, and there's a local case in Georgia about Tex MacGyver.
Yeah.
So that was from a few years
We're going
ago.
to do a show on Tex, but I will get back to that later. But yeah, you're right. Tex MacGyver is a recent case out of Georgia that got kicked back. Go ahead.
And it got kicked back because of extraneous, irrelevant information, or could have been relevant, but the probative value was substantially outweighed by the unfair prejudice. And I feel like there's just so many cases where people are in prison where similar transactions have been used to basically confuse the jurors as to the issue. They haven't. There's no studies of jurors being able to separate. You can only consider this for absence of mistake, or only consider this for identity, but not against them in general.
Yeah.
Jurors can't separate that, and there's no reason to think that they could. And it just creates a situation where there's mini trials within a trial that have literally nothing to do with what the person is being accused of. Now, I have a case on appeal right now. Just to be quick, it's a murder case. I was not the trial lawyer. Actually, Keith Adams was the trial lawyer. That's Young Thug's lawyer. He was the trial lawyer. Client was convicted of murder. They brought in a similar transaction that was an armed robbery. The murder was not an armed robbery, so really dissimilar. I was actually the trial attorney on the armed robbery, which was tried after he was convicted for the murder, and we got an acquittal. He was found not guilty.
Yeah. So what for everybody who's watching this, what she's getting at. So just to make this very clear, by the way, when we use phrases like similar transaction, that's lawyer lingo for a prior bad act. Georgia law used to refer to these as similar transactions, but we have a new-ish now evidence code where we've essentially adopted more or less the federal rules of evidence. And by the way, not every state has adopted the federal rules of evidence, but the concepts generally are more or less the same from state to state, no matter what the terminology is. So I use the federal rules as an example here just to sort of illustrate the point. But what Rachel just said, in case you missed it, folks, she had a case that she won. Somebody was found not guilty of armed robbery. The person there was another arrest, and the court let the prosecutor use the charge for which he was found not guilty, use that against him in a later prosecution.
Yep.
Yep. And speaking of Rule 403, I wanted to point one other thing out here. So we've got this, it's a balancing test. We've got the it says probative value is substantially outweighed by the danger of unfair prejudice. So not just any prejudice, it's got to be unfair prejudice.
But wait, there's
And
more.
under
But
the,
wait, there's more. Keep reading, because there's also confusion of the issues, misleading the jury, and then also considering undue delay, waste of time, and cumulative evidence, which is coming up a lot again in the Young Thug case.
Well, it's not enough under the federal rules for it to outweigh the danger of unfair prejudice. It has to substantially outweigh the danger of unfair prejudice. So who decides that? Well, it's the trial judge. It's the trial judge's subjective opinion on whether it outweighs it, but does it substantially outweigh it? So the judge has to use his or her own subjective interpretation there to decide if something's going to come in. And there is a lot of discretion, but
I've never seen it left out. I've never seen a judge leave it out. I'll put it that way. And I think the question becomes for these judges is not whether there's whether the probative value is substantially outweighed by unfair prejudice. It's whether they're going to get reversed on appeal
that's what judges are concerned about. And speaking of being reversed on appeal, this brings us to, I want to start going through some of this. This is the New York Court of Appeals. And by the way, the Supreme Court in New York is the trial court. For example, Donald Trump is on trial in the Supreme Court, believe it or not. And so the highest court in the New York state is called the New York Court of Appeals. It's weird. You hear a lot of people get that wrong in the media, but hey, it's just one of these things that sometimes the media gets wrong. All right. So we've got this opinion, and I'm not going to read all of it. You'll be glad to know. But I would encourage anybody who's interested to go read it because there's some good stuff in there. But we're talking about, again, this is not about Harvey Weinstein, guys. I'm not making this show about him. This is a vehicle that we're going to use to talk about this particular subject. And it says here in the very first paragraph, the right to a fair trial is a fundamental liberty secured by the 14th Amendment and the presumption of innocence, although not articulated in the Constitution, is a basic component of a fair trial. And I think that they led with that because, look, this was a 5-4 opinion. There were 4 judges, justices, I guess, in this Court of Appeals that did not agree. And you can, if you want, you can go read their dissents, but we're not going to get into those either here today. But these, whoever wrote this, Justice Rivera, I think this was worded this way in order to help explain, how he arrived at this. Okay. All right. So I'm going to get down to page 18 here. All right. Evidence of a defendant's uncharged crimes or prior misconduct is not admissible if it cannot logically be connected to some specific material issue in the case and tends only to demonstrate the propensity to commit the crime charged. Well, what that is, that's Rule 404B, and that's also Rule 403, but it's worded a little bit differently here, but the concept is the same. The uncharged crimes or prior misconduct is not admissible, okay, if it can't logically be connected to some specific material issue. All right, and then this, let's see, I've go down to page 25 here. This is a very, I think, a very well worded opinion. It's really interesting read. And like I said, I encourage everybody to read it. But anyway, they point out here, our analysis here is grounded on bedrock principles of evidence and the defendant's constitutional right to the presumption of innocence and a fair trial. This is they keep referring to fair trial. And this is why they reversed it, because regardless of who you are, if you're somebody that everybody loves or somebody everyone hates, like a Harvey Weinstein, you're still entitled to a fair trial. And here when they talk about the Molyneux and Sandoval rulings, this is what happened. The judge in Weinstein, the trial judge, let 3 women testify who were basically saying, look, he did something similar to me, right? And so what this appeals ruling is saying is that these rulings had what he says is a synergistic effect that deprived the defendant of his right to a fair trial. And so here we go. This is, and he points out that like many other sexual assault prosecutions where the complainant and the defendant are the only ones who know for certain what happened, basically these other two witnesses were used to bolster the testimony of the complaining victim in the case who that's what he was on trial for. And so the justices are saying when you add these other three people to this mix, now we're talking about unfair prejudice. All right. So moving on, we've got here on page 39 of the opinion, they refer
That's
to a
wild.
significant probability that absent the trial court's erroneous ruling, the jury would have acquitted the defendant. So they're basically saying if the judge didn't let all this other stuff in, there's a good chance he would have been found not guilty.
They only do that for people that are powerful and that they like. Because again, that requires a subjective analysis of whether it was an unfair prejudice. I felt that the case was unfair. Like they just had a bunch of women coming in there to say that he just generally did things to them. And it seems like propensity evidence, but it happens every single day to people that are of less high value to people in power. I just want to be very clear about that. And they'll just say it didn't affect the verdict.
Well, and we've seen some of these things play out, Rachel, so far in the case involving Donald Trump that's currently in trial. The judge is making some rulings. Oh, and by the way, some of the rulings that the judge is making, they're saying, look, if he testifies, that he meaning Donald Trump, but in this case, he being Weinstein, the judge was going to let them cross-examine Weinstein on a whole slew of other things as well. And so what it does is it basically impacts the defendant's choice about whether or not to testify. And essentially it deters them from exercising their right to testify. If the judge says ahead of time, if you get on the witness stand, they're going to get to come after you and talk about all sorts of other things that you may have been accused of in the past, whether you were charged with them or not, or whether they're true or not. They get to cross-examine you.
It dilutes the burden of proof that they're supposed to prove beyond a reasonable doubt that somebody did a specific thing, the elements of a crime, the essential elements of a crime, not that they're a piece of shit in real life.
So they conclude the majority opinion. They say, thus, it is an abuse of judicial discretion to permit untested allegations of nothing more than bad behavior that destroys a defendant's character, but sheds no light on their credibility as related to the charges lodged against them. The trial court's ruling ran afoul of these time-honored rules of evidence. Accordingly, the appellate division should be reversed and a new trial should be ordered. And so, again, this is the court in New York is hanging their hat on the issue of basically the trial judge let all this stuff in. It slimed the defendant to the point that the jury just hated him. And if you had not let this other stuff in, judge, then the result would have probably been different. And so we're going to say that you, trial court judge, abused your discretion in letting all this stuff in.
Well, and what's really messed up, and this is what most prosecutors' offices do, because they just can't admit when they're wrong, and they try to double down. So, that order is pretty scathing to the extent that they're saying that if you don't have those other prior bad acts, he's probably going to be found not guilty. State says, we're going to retry him. Can't wait to retry him. It's like, just shut up. I mean, I'm not saying that they shouldn't retry him. I'm just saying you don't have to. Now you need to assess the real evidence in your case. And then we heard that lady in the news story talking about how this is going to affect women coming forward.
So Jason points out here in the comments, and by the way, we have 430 people here. Welcome. And if you didn't join us at the beginning, we're talking about Harvey Weinstein and his case being overturned because the trial judge abused his discretion and let in a whole bunch of evidence that, while it might be arguably relevant, it tends to be the kind of thing that basically asks the jury to convict somebody based on their character versus the evidence of the crime on which they're on trial for. Jason mentions, and I don't know if this is true. Rachel, have you heard this? Harvey Weinstein had the same judge that Trump has now, Judge Merchan. I don't know if that's the case, Jason, but I mean, that's certainly illuminating.
That's
Rachel, do you know who the trial judge was?
I'm going to look. No, that's interesting luck.
All right, Rachel's going to look that up. Thank you for bringing that to my attention, Jason. I had not seen that before. By the way, those of you who are in here, again, thank you. Go ahead and hit the like button. That's one of the things that helps us here inside the law to bring you not only this content, but future content that we hope is going to get better and better and helps us improve the channel. And by the way, if you like the content, this kind of content, other content, go ahead and check out the links in the show description. Those are ways that you can also support us here inside the law. All right. Mark says he salutes you, Rachel. And let's see, we've got, we'll get some more comments in here before. All right. So this is a little bit off topic, but there's, if you've seen maybe my Twitter feed and some others today, recently, apparently Fonnie Willis was at a party in Miami. We'll talk more about her another time, I promise you, but it's certainly very interesting. All right. Now, this is a good point here that all courts should be live streamed for the public to see. I tend to agree.
Amen. It's 2024. You know, a court basically hiding behind a court reporter who has to transcribe everything and then having to pay per page seems like a lot more antiquated and inefficient than allowing us to see people and how they say things. Oh, yes, Robert. Amen.
Rachel. All right. So have you ever experienced a case where you think your client, despite I'm sure your very best efforts, was unable to get a fair trial?
Yes, several I can think of.
Well, you don't have to give us all the details, but tell us what kind of things you've experienced in real life that that prevented people, or were instances where you saw people that didn't get a fair shake.
Okay. I'll start with the concept of trying people together. I tend to think that people do not get fair trials when they have a co-defendant and the two of them are being tried together, and add 2 to 3, 4, 5, 6. The more people that you add, the less fair the trial is going to be for them. Just fundamentally, it's difficult to distinguish what one person did from another person when they all look alike and they're sitting at the same table. Second thing, I've had many unfair juries, I would say, because the prosecutors, even in places like Fulton County, where, you know, half the population is African-American, they managed to strike all Black people from the jury because Black people will say, well, yeah, we know people who've been mistreated by the law. So they're not necessarily kicked off because they can't be fair and impartial, which is what they're asked. It's the idea that they've had negative experiences with law enforcement, so they strike Black males. I've had 2 gang murder trials where we had no Black males on them in Fulton County. One of them,
that's incredible. I don't know how you can wind up with an all-white jury in Fulton County. That's insane.
It's despicable. It's why, yeah, it's honestly the most unfair thing ever. But we can keep going. You know, you have prosecutors who flip witnesses and give them deals without really telling anybody. It doesn't seem to necessarily be about the truth. I've had many clients who were juveniles charged as adults that I don't think that they really took into consideration what the best outcome should be for someone who's completely misguided. Like, you send them to jail for 10 years, prison for 10 years, they're going to get out and be worse. You know, when you have an opportunity to try to restore people, they don't. They do the most. What else can I say?
Well, we've talked, you and I've talked in here. We've done some shows. We'll do more about what they call the YSL, or the Young Thug trial, going on here in Atlanta. And some of the people in the comments are pointing to that as an example of a trial that might not be exactly fair. And take a look at this.
Man, can I get a water or something? I'm so high right now, y'all. I'm about to go to sleep on y'all now. I ain't gonna tell you no lie.
Yes, you may. We're gonna take a break. Hang in there.
Well, that's kind of that we've seen that before, and I think a lot of people in here in the chat right now have seen that before, but maybe some of you haven't. And that's we show that. I love it. It's one of my favorite clips to show in here. I've kept it, and I'm going to keep it forever, I think. But I point that out. We're talking about a fair trial, and so here you have, this is an actual trial that's underway right now in the Fulton County Superior Court, where a bunch of guys are on trial for, you know, their lives. And it's not a death penalty case, but it's a case that carries a lot of prison time. So their lives literally are at stake here. And so this is the kind of evidence that a prosecutor, this was a prosecutor's star witness. They brought in a guy who was under the influence, and he was so high, he was about to fall asleep. How in the world can a jury reach a fair decision if that's the kind of evidence that prosecutors bring?
Well, what the state, ironically, what the state is going to try to do is say that those witnesses that refuse to cooperate are really just scared, kind of like Terrence Bradley was just scared when he wasn't remembering anything on the stand when he was called to testify about Fani. I mean, if there's an underlying, suggestion that YSL and its members are somehow intimidating the witnesses such that they won't testify, the same thing holds true to Fani and Terrence Bradley. I just want to say that, but that's all they can really do is say that that's how scared they are of these people, that they won't even, they won't even be honest in front, even under oath. But
all right. Well,
Okay.
look, I've had my own cases where I thought were completely unfair. One particular one comes to mind where my former client is now serving what's going to amount to the rest of his life in prison for something I'm 100% sure he did not do. It was actually another sexual assault case, but in that case, I was basically prevented from presenting a defense because I had solid proof that this was consensual. I had statements of the victim to that effect, and the judge would not let me use that evidence. And lo and behold, he winds up convicted for something he did not do, and it somehow got upheld on appeal as well. And so I could go on and on, but these things do happen,
and they haunt you because it's so upsetting.
Well, people say, well, well, he's just a criminal. It doesn't matter. Well, they're not all criminals. I mean, the hardest ones, people ask me, say, how can you represent these criminals? Well, first off, they're not all criminals. Some of them are. Hopefully the police get it right most of the time, and they do. But there's a significant percentage that where it's wrong. And so hopefully we can do something about that. But going through the process of the arraignment, the pretrial hearings, the motions, all the court appearances, and then sitting through a trial, the process itself is extremely punitive and taxing on people. But from as far as criminal defense goes, I'm interested to hear, Rachel, what you think about this. But to me, the hardest ones to represent are the ones that are innocent. And by the way, most of what we do is by far, I think we negotiate plea deals in something like 97% of the cases. And so what we're after fair sentencing, and everybody should agree that sentencing should be fair. I mean, prosecutors will agree with that notion, judges, the general public, everybody tends to agree that criminal sentences should be fair sentences. So that's the overwhelming majority of what we do. But the cases that keep us up at night and that haunt us are the ones where people are accused of crimes, and sometimes very serious crimes, and we believe them to be actually innocent. And those are the ones that sometimes you can't get a plea deal on either.
Yeah, it's like, I think it's hard because my understanding of what punishment should look like is a lot different than oftentimes what a prosecutor is desensitized into believing is, a right number of years to put somebody away in prison. I also have a really hard time when people are grouped together in either in a gang case or in just a regular case where they're all charged as parties to the crime, meaning they're as guilty as the person who actually committed the crime because they're accused of aiding in some way or encouraging. Not everybody thinks the same thing. And so some of my hardest cases have been when I feel that my client is taking a plea for something, or I'm having to have him just to avoid being slammed at trial because he's being charged with everything that was done outside of his presence and he had nothing to do with. But if we lose, his life is over. And sometimes it's more important to be free than right in a system that gets it wrong. So I'm really about accountability too. So I kind of feel like if my client can take accountability, make changes, and the punishment makes sense, that's the best solution. But oftentimes we just can't agree, putting a 15-year-old in prison for 25 years because he's, because of accusations of one person that can't be supported. These sex cases are really hard. I try not to take them because we're in a culture now where I feel like it's disrespectful not to believe someone.
Look, everybody's not worthy of belief, are they?
Well, I agree with you exactly, but I have not been particularly successful in getting a jury to consider the possibility that it's something other than what the girl is saying.
Well, this reminds me, now that you mentioned that, this comes to another case comes to mind that was from several years ago. It was another sexual assault case, and this one I did win. And I also knew that he was innocent, but he spent months and months and months in jail on charges because he couldn't get a bond, and it was for something that he did not do. And I was able to conclusively show, I think, during the trial that the alleged victim was making it all up. And I'll spare you the reasons that I knew that, but suffice it to say, when I talked to the prosecutor, early on the case, I kind of brought him some of this proof that I had, and he said, well, why would she lie? I'm like, I don't know why, but here's the proof that she did, but it got ignored.
Yeah, why?
So we had to go to trial, spent 2 weeks in trial. And listen, as we left the courtroom, it was like 9 o'clock on a Friday night, and we had been there all week, and the jury came back not guilty. And there was a group of people that were associated with sort of her side of things, and they started creating a scene in the courtroom. And so the judge had myself and my co-counsel and my client walk out. He made everybody stay. He said, y'all get out of here. And as I was leaving the courtroom, I heard the judge say to those people on the front row, we did everything we could for y'all. And I'm thinking to myself, who's we, Judge? Are you on their team? I mean, is this, is this the kind of system that we have where judges admit openly in open court that they're taking a side, and yet somehow we still manage to win?
Yeah, you're like, well, actually, the jury spoke, Your Honor. But yeah, I mean, some people are motivated. That's the reason I wouldn't be a good juror on an animal abuse case, because I can't hear about it. I don't want to hear about it, and I'm going to assume a lot of bad things about you.
Yeah, and it's one of these things where, look, guilty or not, if we as a lawyer have some particular issue, like if we can't deal with the subject matter, then we don't need to deal with the case, regardless of the issue of guilt or innocence or whatever. But we can't. We I think probably have an ethical obligation to steer clear of cases that we just can't objectively deal with the subject matter. And I have a group of cases myself that are in that category, and I'm an animal person too, so I completely get it. All right, so look, we have over 500 people in here now. Thanks again to everyone, whether you just are joining us or if you've been here the whole time, or if you're new to the channel.
Hello.
Please go ahead and like and subscribe, and tell everybody to please subscribe if they have an intellectual curiosity. And if you like this content, please help support the channel. There's links in the show description for that. We're at about 37 minutes in, and so we're going to move on to our next topic, Rachel. And I know this is something that you and I have been talking offline about, some of this, and I'm very curious to get some others' reactions. But we've seen a lot of social unrest lately, and we're not going to get too deep into the social issues, but I want to talk about these protests, some of which have turned ugly. They've turned violent. And so we've talked about the First Amendment here inside the law. And so this is a good way to circle back and further explore the First Amendment. And there's a difference in protesting peacefully and exercising your First Amendment rights. But then the crimes that sometimes result, I mean, there's oftentimes things start peaceful and maybe they get unpeaceful, and sometimes they're just unpeaceful from the very beginning. But you hear people say, well, we're just out here exercising our First Amendment rights. Well, I got news for you. No, you're not. So that was at Emory University here in Atlanta a day or two ago. And when I saw that video, I'm thinking to myself, my God, those officers, their lives are in danger, like right now, as in real time. And all of those people that you saw shoving against him, trying to break into a building that they had no right to be in, they were endangering the lives of those officers. they were committing, in my opinion, they were committing the crime of, well, I mean, you've got false imprisonment, you've got battery and all sorts of other things, assault. And so those people were actively committing felonies, and those officers were terribly outnumbered. And I'm really glad to report that I'm not aware of any injuries that resulted from that, but that was just insane. Rachel?
So I think, was that at Emory? That's at my,
yeah.
Yeah, that's where I went to law school. So in that, a few thoughts just from that video. I don't know why they wanted to get inside, why those individuals who are probably students, the way that they were pushing towards the door, I'm like, what are you going to do once you get inside? Like, what are you doing? Not to mention, I'm scared of crowd crushes. I don't know about you, but those officers were in a really, really bad physical position from a safety standpoint, that you have a bunch of people rushing the door. And I think those doors were probably locked.
Yeah, they were. I mean, they were trying to go in and start one of these occupation zones in there. That's trespassing. That's not their property. They don't have a right to it. They have a right to speak and be heard and that kind of thing and speak, but they don't have a right to take over property that doesn't belong to them. And they don't have a right to endanger those officers like that.
No, a lot of these students at these universities, I've been reading about it. I have some personal interests in it. So what's shocking to me is that these student organizations are making demands of the universities. And we can talk about Intifada in a second, but to basically divest from any to boycott all things related to Israel. But they're making demands as if they're somehow at the table with some sort of power. It's almost, I'm like, are you guys pirates? Are they, I mean, they're making demands. They're literally taking everybody hostage and saying, if you don't do this, we're going to do this.
And it is remarkable how many don't really understand what they are supposedly protesting.
You guys are shouting for Intifada. You know what an Intifada is? What is it? What is an Intifada? You guys are proud of shouting for Intifada? Yeah? Woo!
Rachel, first question for you. First off, why are they all still wearing a mask? And secondly, help us out. What is an intifada? I'm sure you know.
Yeah. So, I mean, they're wearing masks because I think they don't want to be identified.
That's right. Oh, no. They're afraid of COVID, right?
So an intifada is basically, historically, it's an uprising of sorts. It's not only in the context of Israel, but there's been lots of intifadas that I know now. A lot of the people that are trying to justify their own screaming of the words intifada, they're basically saying that it can be part of civil disobedience or civil unrest. And that it doesn't necessarily have to involve violent uprisings and violent terrorism. However, historically, it has not involved peaceful protests. It has involved, and especially in the context of Israel, it has involved terrorism, suicide bombers trying to take over, kind of like October 7th. So what they're calling for is terrorism and violence against what they consider to be Zionists as a bad thing. So.
All right. Well, there's something else here that I want to point out for folks. There is an interesting way. I found that at least a creative way. At least one place is dealing with this. Check this out. I don't really know a whole lot of context for that, but I saw it. And what it was purported to be when I saw it is they're trying to make it physically uncomfortable for them, I guess, but that was a situation where, see, those protesters seem to be protesting peacefully at the moment. And I don't know, why they had water on them, but that's, we have various degrees of this, because this is the other day at Ohio.
Media.
So there's some police there that were, I guess, a little bit better equipped in terms of the gear to deal with this this potential crush than the folks we saw at Emory. But there's another, speaking of Emory, there's another issue that's coming out of Emory University, and here it is.
You are fascist. You are Hitler. You are a rabid dog. Shame on you. May you never live another day.
I am a professor.
This is an Emory professor, everyone.
I am a professor of economics.
You are rabid dogs. You are fascists.
It was a peaceful protest until they started fighting troopers. I agree with you.
L-I-N. I reacted impulsively. I apologize.
No, you're right. It's right to rebel. I'm gonna share this.
Please remove the handcuffs.
Get back! Get back! Get back! Get back! Castro.
I want my purse into my black bag.
Do you want me to get a hold of John?
I want you to call John. Yes.
I'll do that.
My phone is at home.
Okay.
Yes.
Okay.
And I want you to understand. Please don't yank my arm. It is,
I'm trying
it
to
is
guide
really,
you gently.
Can you please show the back zip ties? They refuse to listen.
Does he have a license?
He has everything.
This is pulling on my hand.
I was doing
They were.
nothing. I did not resist.
Do you have everything you need?
Hey, we were not resist. I barely did anything. I came here when I heard that they were arresting. Cops were coming to arrest our students, and I came here and I saw a large man pinning one of our students to the ground, pressing on his neck and potentially choking him, causing life-threatening injury. And so I impulsively hit him on the head very lightly to get his attention, and they grabbed me, threw me to the ground, and arrested me. And they are now injuring my arms. They smacked my head on the pavement, and you can see that they hit my face on the concrete, and there's probably bruised, and you can see scratches. And they are now manhandling me without any kind of due process. They are manhandling me, and I'm refusing to call my husband or anybody else to help me.
Okay. I will phone him now, okay?
All right. So that was also Emory University, and the person that was being arrested is a professor there. And there's another, you can see in the video, they're making an arrest of someone, and she decides, and based on her own words, I have to take her at her word, she put her hands on a police officer. I think she said something like she hit him on the head, right? Even if it was lightly, she injected herself into an active arrest, and that's a crime. You can't do that. You cannot interfere with a police officer carrying out their duties. It's called obstruction here in Georgia, and it's against the law. So you just can't do that. And then, so when they went to arrest her, it appears, to me at least, that she was resisting herself a little bit. She did not want to be arrested. Who does? But, it looked like she was not complying with, putting her hands behind her back and that sort of thing. And the officer took her down. And look, I want to know what you guys in the chat think about what you saw. I'm very curious to hear y'all's opinion, but the bottom line is it's not a peaceful protest when you put your hands on a police officer who's carrying out, their duties. Rachel?
I mean, that's just how confused these individuals are. Thank you. Thank you. No, how absolutely confused they are, thinking that they can continue to obstruct law enforcement. That's felony obstruction of law enforcement.
Yeah.
I've seen people arrested for less. And again, I'm not someone who wants to scale up on arrests and prosecuting these people. There just has to be a difference between a peaceful protest in a place and time that are appropriate, that you're allowed to be there. I mean, if you're somewhere after hours, it's criminal trespass, just like everybody else, whether you have demands or not. And they're just so confused about who's in charge here. And that she was gonna come out of her professor, out of her class to come, I guess, stop police from doing their job because she agrees with what the students are doing. She didn't see why they arrested that guy. And she's not going to be the one, as much as I might want to interfere with an arrest, it's the last thing you should ever do. I'm surprised she didn't get tased or worse. And she wasn't complying. I don't like the physical encounter with police, but for her to act like, I just impulsively decided to hit him. I love that kid. And we can watch him too. I just impulsively decided to hit him lightly on the head. You can't do that.
All right. So I wasn't able to pull this video off for some reason, but I'm going to make this, let's see if I can make this full screen. This is currently, you can check it out. It's on my Twitter feed. This is a Georgia State trooper who I am personally shocked that he didn't injure himself. But look at this guy. So he decides going to flop down on the ground. And he's not going to go anywhere. So the trooper just, without missing a beat, just picks him up and just totes his ass right off, like a parent pulling a screaming toddler. But this is absolutely, some people are thinking it's funny. I think the trooper is showing a lot of restraint here, and at least has the decency to pick him up and carry him instead of dragging him by his hair, which is what maybe I would have done.
I hate that it's come to that, but again, kind of going back to protesting and the point, all these things, how is that interaction with law enforcement or even trying to fight law enforcement? How are you helping whatever cause you're supporting? Which seems to be free Palestine from Israel, whatever they're saying. I also wanted to say, I think they're called keffiyehs, that scarf that they wear.
Yeah.
I want to know how there's been a giant spike in the sale of those in America in the past week.
Oh, I'm sure.
It feels like it's just like the new thing to wear. And so all these young kids are just enjoying, cosplaying a Palestinian, basically.
All right. So those of you in the chat, tell us I want to see what you people think. So Daryl says he sees no misconduct by the officers in there. And let's see. Michael points out, just picked up a resistance. That's absolutely correct. Tell me what you guys think. I want to know, did you guys see any police brutality, officer misconduct? I didn't, but I want to know, and I'm not always right about everything. Believe it or not, I'm not, but I want to know what you guys think. By the way, there's still 521. Thank you guys, everybody, for being here. Please hit that like button. That's going to help us continue to bring better content. The thing is about all these arrests. Okay, so they all get arrested. They're taken to jail. Presumably, they make bond and get out. Rachel, do you think they go right back out there, or do some of them who get arrested actually steer clear after that? What do you think?
It's a tough call. So I know that near Emory, because I'm involved with an organization that represents a lot of these protesters. So it got kind of weird for me. None of them were charged with felonies, and all of them have been released on bond. But I don't think it'd be that surprising if these individuals got arrested again at a different protest. I'm hopeful that none of the kids from the Cop City case are going to get rearrested, and we're going to have to deal with that. I'm involved in that case too, which I want to say again, there are peaceful protesters. There are people out here that think that they're screaming for, a peace in the Middle East kind of thing. But when you're screaming intifada and the final solution and Zionists are genocidal maniacs and they need to go and be killed, that's not a peaceful protest anymore.
Well, by the way, I probably should do a show or a stream on the issue of police use of force. It's actually something that I've studied a lot. I'm a former officer and I still keep up with the same training. But the test for whether or not someone or a police officer has used too much force is whether an objective, reasonable officer under the same or similar circumstances would have done essentially the same thing. So it's like an objective test. You You're not supposed to look at it through the 2020 lens of hindsight. You're supposed to look at it. The Supreme Court actually tells us this. You're supposed to look at it through the eyes of the officer on scene, and then decide would a reasonable officer under the same or similar circumstances have done the same thing. Because look, when your back is literally against the wall, and it's you're in fear for your life, perhaps, all of that has to be taken into context. For those of you who might have missed it, I want to show this one more time. Those are some police officers who, and the video is much longer than that, but look, the point I'm making is put yourself in their place in that moment and ask yourself, would they have been justified to have pulled out their weapon and started shooting people? Would they have been justified to take out some type of baton, or would they maybe a stun gun or a taser? Would they have been allowed to use some extra degree of force? They weren't using really any force there at all, at least not in that video. They were the ones having force used on them.
Yeah, they were defending themselves from being crowd crushed. So
yeah, well, if they had started using a lot of force, it would have gone probably very badly for them, because they were so overpowered, so to speak, and outnumbered that I'm sure that it would have been dangerous for them to have started trying to use any degree of force. But it's literally with their back against the wall. They're afraid for their lives. You just have to examine their conduct, their behavior through the lens and the context of the situation that they're in.
In any other circumstance other than a protest, anybody doing that to police, you're absolutely getting arrested. If you're just out here, physically attempting to push them and prevent them from, doing their job, whatever that is. They could not get out. They were basically trapped.
By the way, some people are asking, where's Megan? Megan's taken she's on vacation. Okay. She's in parts unknown. She's, I'm sure, living her very best life today, but she sends her regrets and says she'll be here hopefully next time, and that she misses everyone. All right. So, look, let's see. Edwin is mentioning pepper balls would have been so effective. Yeah, maybe. But look, these guys were significantly outnumbered. They were doing all they could just to keep their lives, I think. So the bottom line on these things is, look, you ought to all know this by now. Maybe it's the libertarian in me. I believe that all of these people, whether you agree with what they're saying, whether you agree with their point of view or not, I will vehemently defend their right to say things that I personally may find to be repugnant, because that's what the First Amendment is. The idea is to have a marketplace, a free marketplace of ideas, so that everybody's voice gets heard. And then the consumer, if you will, the consumer of ideas, the people who are considering everyone else's viewpoint to try to shape their own viewpoint, the consumer of ideas can decide what makes sense to them and what doesn't make sense to them in formulating their own beliefs. And so my default setting is more speech and not less. We've talked about censorship here before, which again, I find to be appalling, but I will support everybody's right to say the dumbest shit in the world, the wrongest stuff in the world. I will support it, but I can't support violence on police officers, violence on other people. I can't support burning. I can't support trespassing and looting. Those are all things that it just goes too far. Yeah, so you can't watch these videos and say, oh, you can't claim to be peacefully protesting. My friend Eric Erickson said on his radio show the other day that something along the lines of, reality is determined by vocabulary. In other words, if you simply say something, apparently in today's world, it must be, that makes it true. Saying it means that it's true. No, it doesn't. You can't say we're peacefully protesting when you're not actually peacefully protesting.
Yeah, well, I guess as somebody who might be labeled a Zionist, because I have lots of family in peaceful family that live in Israel, we may not agree with, the politics of the Israeli government, but basically they're saying that, there's people screaming for the destruction of Zionists and to kill them. That's what was going on at Columbia. So in addition to the burning and all that stuff, you can say things but that aren't threatening to people that are listening. You can't say you're going to kill a bunch of people. Just imagine if the KKK just like strolled in and not just did a little march, but that they came in and started, talking about,
which they would have the right to do, and they have done.
Oh,
and
yeah.
The police are there to protect them. When you don't see it that much anymore, but we used to see from time to time, you would see actual Klan rallies and marches, and you would see police officers lining the parade route or whatever in order to protect them from counter protesters, because that's what cops do. I mean, it's they're out there to protect people when they're exercising their First Amendment rights, but they're also there to protect my right, my safety, my property, and yours as well. So we may find and do find, I think, the Klan message to be repugnant and repulsive and vulgar and everything else you want to call it. But again, I support their right to have that opinion and to voice it.
I do, as long as they're not cornering, people that they hate and preventing them from leaving, or burning things in their yard, threatening to kill people.
By the way, I want to take a minute to say thank you to the new members. I need to look at the numbers. I think we're over 200 members now, which I find to be, that's just awesome. I'm truly humbled, and I think that's amazing. And I don't really know anything other to say other than just say thank you all very much. And Sam, thank you very much for the super chat, and welcome Kimmy Joe. And look, I mean, Gene just gifted 10 memberships. That is incredibly generous. And so I just want to say thank you. And again, please hit the like button if you haven't already done so, and tell everybody that to please come on in here and also hit the like button, and also subscribe, because that's going to help us continue to bring you this content. So someone mentioned earlier, and I want to circle back to this. We were discussing the issue of why these people cover their faces.
You guys are shouting for intifada. You know what an intifada is? What is it? What is an intifada? You guys are proud of shouting for intifada?
So every one of them, that's not the full video, we showed it earlier, every one of them with their face covered. And Rachel, do you remember in Georgia when it was a crime to cover your face in public, with the exception of perhaps on Halloween?
Yes, because I watched a really great episode with Sacha Baron Cohen, Who is America on I think it's HBO or Showtime. Highly recommend it. And there was a local guy talking about the anti-mask law. I mean, I like to be able to see people's faces. It's kind of scary not to.
All right. So COVID came along, and the recommendation, of course, was to wear masks everywhere. I never was a fan, but I'm not going to get into that right now. But it was a crime here in the state of Georgia, where you and I are, to cover your face, with the exception of maybe out on Halloween. And the reason it was a crime is because the Klan historically would cover their faces when they would commit atrocious crimes. And so this was an anti-Klan type of law. It was on the books for that reason. And also the other reason is because it made it hard for law enforcement to identify people when they're investigating crimes. So the wearing of the face masks became normalized during the COVID pandemic, but now these masks are being used for people who just want to hide their identity. And so I personally think we need to get back to outlawing masks and the covering of the faces in public for that reason. Joe says that they cover their face. He says because they're ashamed of what they're doing. I don't think they're ashamed, Joe, but I mean, look, maybe they are. I personally think they just don't want it. They want to hide. I think they're cowards, honestly. I think that's what it boils down to.
Well, they don't want to take responsibility for what they say. They want to say things without consequences.
And this is another interesting idea. So many times those with face coverings are paid protesters and organizers. And I think there's some of that in this as well. But Emery came out. We were talking a lot about Emery with these videos here in Atlanta. Emery released a statement when this whole thing kicked off earlier this week, saying that most of the folks that were being arrested and that were actually trying to take over their they're setting up the tents and all that. They said that most of them were outsiders. They weren't from this community. They weren't from the area. They had no affiliation whatsoever with the school. And I think there's some truth to that. But look, we can't, I'm not going to quibble too much with somebody's motivation for protesting, because if you feel strongly about something, fly wherever you want, go to any other state, go wherever you want, and let your voice be heard. But don't pretend that this is a grassroots organic sort of thing when it's not. And don't be a coward. Show your face. Let us see who you are. If you have this opinion, say it. I'm here on the internet right now telling you what my opinion is. I got my name on here, but I'm willing to say my opinion and put my name on it in my face. And I think that that's just the way it should be. And I think that if someone feels very strongly about it, then let us know who you are. So that way maybe we can understand why you feel that way. Rachel, what do you think?
I mean, I clearly have no problem showing my face and saying what I mean. I mean, I feel like there's competing interests. I mean, I think part of them is ashamed of themselves. Part of them realizes that they have no idea what they're talking about and that they have no skin in the game. And so they're just kind of there to enjoy what otherwise would look like a festival. I'm like, why don't they just go to like Burning Man, since they just want to like set up tents and, bang on drums? That's cool. Like that's fine. It's just some of this other,
Stephanie makes a good point. The peaceful protesters get the hell out of Dodge when it gets violent, and I've seen that too, and I think that's probably true. All right. Well, look, we've been at it an hour, and Rachel, I know you've got other things you want to do. It's Saturday. You got any big plans? I'm going to the Braves game. As you can see, this is when you see me wearing this, it means I'm going to the Braves, and so I start getting ready before I come in here. What you got any big plans?
Hanging out with my dogs.
What kind of dogs do you have?
Well, I have a Mastiff. I have a Rottweiler. I have a Bloodhound German Shepherd. My boyfriend has 2 pitties. I have a cat. So it's just going to be an animal.
It's a zoo. It's a zoo over there, literally.
How I like it.
All right. Joe says if you have a strong opinion, you should want people to know who you are and see, that's what I was trying to say a moment ago, but I didn't put my words together as succinctly as Joe did. But thank you for that, Joe. That's exactly what I was trying to say, even if it was inarticulate. Rachel, we'll let you go. Thank you so much for spending some time with us today, and we'll be in touch about what we're going to do next.
Sure. Hopefully next week we're going to have some cool lots of cross-examination in the Young Thug case, which I can't wait for. So
yeah, we're gonna Young Thug. We're gonna check in on Young Thug soon, but also I think, Rachel, we're going to hear something in the very near future. I think it's going to be this week on whether the Georgia Court of Appeals is going to hear Ashley Merchant and the other attorney's effort to disqualify Fonnie Willis. I think we're going to get a ruling from the Supreme Court. It's not a ruling on disqualification. It's a ruling on whether they're going to hear the appeal. I predict they're going to hear it, and I predict we're going to hear that this week.
Let's see. We'll be back. Have a good Saturday, everybody.
All right. See you, Rachel. And guys, thank you all very much for coming in here again. Please hit the like button, subscribe, tell all your friends to subscribe. And by the way, if you like this content, please, by all means, check out the links in the description to these videos and this very video, as a matter of fact, and help support Inside the Law so that I can continue to bring more and even better content. And with that, folks, thank you all very much, and we'll see you next time here Inside the Law.